Say to all the participants in this International Virtual Summer School of 2023, organized by Nivaaran, Mediators of Supreme Court of India in collaboration with Singapore International Mediation Center, SIMC as it is known worldwide, and the CLA, Commonwealth Lawyers Association. Today we are on the second day of this summer school. Through the previous 2 days, deliberations over various aspects of mediation by our esteemed guest speakers, and also through the thought-provoking questions from our participants, it's been a great learning experience that has amply enriched our participants' knowledge about ADR or alternative dispute resolution. We have seen how with the advent of adjudication, where is there any problem? We have seen how with the advent of adjudication where one size fits for all, the stakeholders of our justice dispensing system slowly distanced itself from the litigants' pain and wants while parties' interests took a backseat. But now, with our government taking proactive steps in introducing the long-pending mediation bill in this monsoon session of the parliament, things have started looking up. Mediation was a practice that was commonly followed in India prior to the arrival of the British and their court system. Not only did the British establish the framework of the modern Indian judicial system, but they were also instrumental in the creation of the myth that dispute resolutions and justice requires black coats and gowns and elaborate arguments. It is time to dispel such myths and notions. So here is Nivaaran taking the mantle and marching ahead with the inspiration and support from other like-minded organizations in creating the mediation mindset in India through continuous awareness building programs such as these summer school every year. Today, we are delighted to have SIMC and CLA, the two world-renowned organizations, by our side in this journey ahead. With this thought of mine, I am happy to announce that in coming 30 to 45 minutes, we will go through the pros and cons of what is conflict, its different avatars, how to manage them, and ultimately the win-win process of its resolution and the transformation it brings on us as individuals and on the society as whole. And thereafter, we will have an interactive sessions via a Q&A session. Here I can ask the participant, they can write their questions in the chat box, or otherwise they can raise their hands directly to have a tete-a-tete with our guest speaker today. So let's have a quick look. Conflicts is a natural part of human interactions and arises when there are incompatible interests, goals, or values between individuals or groups. It can occur in various settings, such as interpersonal relationships within a family, at workplaces, among communities, or international relations. It can be both constructive and destructive, depending on how it is managed and resolved. Understanding different styles of conflict and conflict management technique is crucial for fostering positive outcomes and promoting growth. Styles of conflict can broadly be categorized into 5 categories. Avoiding style, which can be appropriate in situations where the issue is trivial or when emotions are running too high. But excessive use of this style can lead to unresolved issues. Then comes accommodating, where we generally prioritize the needs and interests of the other party over our own. But it can lead to feelings of resentment if one party consistently accommodates the other. Then competing. Competing reflects a highly assertive and uncooperative approach to conflict. but it often leads to damaged relationships and can exacerbate conflicts. Then comes the compromising style, which aims to find a middle ground where both parties give up something to achieve a partially satisfactory resolution. But it often leaves both parties unsatisfied or dissatisfied. Collaborating is the one which emphasizes cooperation and mutual problem solving. Collaborators actively seek win-win solutions by openly sharing perspectives and exploring creative alternatives. This approach fosters constructive communication, strengthens relationships, and addresses the root causes of conflict. Now, without taking further time, let me introduce our revered guest speaker for this session. Today, our honored guest speaker is Mr. John S. Bassie from Jamaica. Presently, he is the president of the Jamaican Bar Association. He is also the global president of the Chartered Institute of Arbitrators, CIArb. He is by profession a barrister at law, an attorney at law, and the managing attorney of the law firm John S. Bassie and Company. To add, he serves as chairman of the Dispute Resolution Foundation of Jamaica, which just celebrated its 25th anniversary and which is the oldest ADR organization in the Caribbean region. Mr. John S. Bassie is a chartered arbitrator, multi-jurisdictional Supreme Court appointed mediator in Florida, USA and Jamaica, and a trainer in ADR. He has enjoyed a distinguished career in these areas of practice for the past 21 years in the Caribbean, North America, the United Kingdom, and Africa, and he had served on ADR working groups at the United Nations too. His presentation today is on the transformation effect of ADR on a society, the Jamaican experience. I urge the participants to take this opportunity to understand how conflict and conflict resolution changes its hues and forms. I am repeating it. I urge the participants to take this opportunity to understand how conflict and conflict resolution changes its hues and flavor depending upon different cultural backgrounds, still keeping their intrinsic character intact. But first, a quick introduction of myself. My name is Sangeeta Mehrotra. I have a diverse background that includes studies of law, literature, history, religion, philosophy, ADR methods and practices, along with public relations management. I gained these experiences through my undergraduate and postgraduate education, extensive interaction with people during my 38 years in legal profession, and over 250 hours of professional training as a mediator, negotiator under various recognized national and international institutes of repute. I am particularly happy to say that post completion of the 5-step assessment process under IMI COAP CAMP CAM, I am now awaiting the formality of being certified as an IMI mediator soon. Today, I am humbled being chosen by Nivaaran to host and moderate this session, where Mr. John S. Bassie will enlighten us with his views on the topic mentioned herein above. So, here I welcome Mr. Bassie to take the floor. Sir.
Thank you so much, Sangeeta. Do I have sharing privileges? Am I able to share the screen to put the PowerPoint presentation up?
Rahul.
So you can share it yourself.
I can? Okay, thank you.
You have the access, sir.
Okay, great. Are you seeing that? Yep.
Yes, we can. It's very much visible.
Okay, great. Okay, good morning, good afternoon, good evening, good night. wherever you are. Thank you so much, Sanita, for that introduction, and also for setting out the framework, a bit about mediation there. This morning, I'm going to be discussing conflict management, resolution, and the transformation. And I think for me, there's no better place to start than probably at home in Jamaica. I also have a background in that I was actually born in London. My father's West African, and I've lived all over the world. So I really consider myself truly a citizen of the world, and I draw these experiences. But in particular today, we're going to look at the Jamaican experience. The best way of showing the effects of ADR is possibly to look at the effect of these mechanisms on a society. Really and truly, conflict management, resolution, transformation will be reviewed through our experience here in Jamaica. And I can tell you that conflict resolution management, these mechanisms, are game changers. Okay, a little bit about our experience. The experience actually started through an organization called the Dispute Resolution Foundation, which in fact was brought into being by the Jamaican Judiciary, the Jamaican Bar Association, in conjunction with the private sector organization of Jamaica, and the Ministry of Justice. So as you can see, the main stakeholders in such an environment came together and formed the Dispute Resolution Foundation, which in fact has been in existence from 1994. It facilitates and practices the application of various ADR or alternative dispute resolution methods by working with the courts, government entities, corporate business, and other departments and agencies. It actively promotes mediation, proper conflict management, effective management of anger, restorative justice, arbitration, and deliberation through seminars, workshops, and intensive training programs. As you can see, it is an organization that embraces ADR. The whole point of it was to organize things in Jamaica in such a way so we can get away from the non-violent ways of disputes in Jamaica and the wider Caribbean region. All right, on your screen, you're seeing three sets of numbers. Sanjita, I might need your help here. 42, 67, 13. Can anybody guess what that is? Any hands raised, Sanjita? I don't want any Jamaican hands. Yes, Advocate Bella Bat. I see your hand is raised. Can you ask her to unmute and tell me what she thinks it is?
Sir, number of cases resolved through mediation?
No, good try. No.
No.
No, it's not. I will, in the interest of time, I'll move on, but it's certainly not the winning lotto numbers either. 42 is approximately the number of judges at the Supreme Court level. 67 is approximately the number of judges at the parish court or lower court levels, and 13 the number of judges at the Court of Appeal. So do you know what is Jamaica's current population? I'll tell you probably don't know. It's 3 million people, roughly speaking. Okay, any thoughts? Do the math. These are the number of judges in our legal system. That's approaching approximately 121, if my math is correct, no, 122, to service a population of 3 million people. Quite an issue. So as you can see, already we are at I wouldn't say disadvantage, but if your system is not up to par, then already you have quite a few judges to service the needs of quite a large population. So I want to look at what's in the ADR toolkit. What comprises ADR, generally speaking, in our region? Well, we have arbitration, restorative justice, conciliation, and mediation. Let's take a look at them. Now, arbitration, that's an alternative dispute resolving method in which a neutral third party listens and reviews the facts presented by the litigants and decides the outcome of the matter. So basically, you have a third party neutral who's acting like a judge, who's been given a set of rules and told, this is your terms of reference. These are our issues. Can you look at the pleadings or hear the pleadings if it's not documents only based, and tell us what your rulings are. Generally speaking, these disputes are property, monies owing, breaches of contract and things like that. And of course, it may be referred by the civil court to arbitration. Access to arbitration services and training in our country and our region are generally provided by the Chartered Institute of Arbitrators, the Caribbean branch, or through the Jamaican chapter, and also in conjunction with the Dispute Resolution Foundation. Restorative justice. Now, this is another tool that's very effective. It's a process whereby all the parties with a stake in a particular offense come together to resolve collectively how to deal with the aftermath of an offense. RJ, as we like to call it, distinguishes itself from other ADR practices simply because it has a clear victim, an individual who's been harmed, an offender, a person who caused the harm, and it is aimed at addressing the harm that was created by the offense and reintegrating the offender into the community. It involves the participation of not only the victim and the offender, but the wider community as well. Our restorative justice services and training have been established far and wide by the Ministry of Justice, and we have RJ muted. Okay, there you go. And the training in RJ is pretty much accessed through the RJ unit in the Ministry of Justice. Conciliation. Conciliation resembles mediation, but there are some subtle differences. Conciliation is a voluntary, flexible, confidential, and interest-based proceeding where disputants seek to reach an amicable settlement with the assistance of a neutral third party who is called a conciliator. This process, it differs from mediation that conciliators may offer their opinions on presented information and make recommendations to settle the dispute, whereas a mediator does not. Despite making recommendations, conciliation still affords the disputants to decide the outcome of the matter. The ultimate decision agreed on the proposed settlement remains with the parties. Now, this ADR method in our country is often used in employment law disputes, where parties will attend our Ministry of Labour, and of course, it kind of levels the playing field, if you will. If you've got a major company and you may have an employee who wants to get their point across, and maybe in a layman's terms as well, and be able to get the point across, and the ministry, through a conciliator, is able to see if they can bridge that gap before it goes on to any sort of tribunal. Mediation. Sanjeet had given us an outline of mediation, and it really is a voluntary dispute resolving process where the neutral third party facilitates and coordinates the negotiations of the parties. The outcome of the process is solely determined by the parties, and they generate the solutions for the dispute. So what it provides us with an improved pace of conflict resolution. Do you realize that the court cases are now being scheduled in our country for as far as 2028? That's 5 years down the road. It offers a cost-effective means of resolving disputes. It allows for continued relationships. It produces creative solutions that can be owned by the parties. In other words, the parties come to that agreement by themselves or with the help of the mediator, and they feel a part of that solution. And it's flexible and informal, and it's without prejudice, meaning that whatever happens there stays there. So how does it actually work in our country? First, there's a formal contact between the party and the mediator. The parties are identified, the ground rules are explained to them, and mediation is defined and explained to the parties. The parties will relate their side of the story. And in that part, the litigant, the claimant will say, hey, this is what I'm claiming for. The defendant will say, this is the reason why, this is my defense to it. If there's attorneys there, they will be involved as well. And the mediator will summarize and capture the essence of the information presented in determining the problem at this stage of the matter. As mediators, you then review the issues to be mediated, and these are identified. It's very important at this stage that the parties recognize that the core issues that are there and other issues that might be auxiliary to the core issues are identified and put on the table. There's a generation of evaluation of alternatives. How can we resolve it? And potential solutions to these disputes are explored and evaluated. The best alternative for resolving the problems are selected and refined, and then hopefully they're agreed upon. DRF is recognized as the primary mediation referral agency. Now, the foundation facilitates court-referred mediations as well as non-court referred matters. In our Supreme Court, cases are automatically referred either by judge's order or with parties' consent. In the parish court matters, judges offer mediation with the parties' consent. Non-court matters, parties request mediation, and that's usually by the general public. To understand how that works, I think it pays dividends to take a look at the legislation that governs mediation, governs mediation in Jamaica. In our resident magistrate courts, or our parish courts, or the lower courts in other Commonwealth jurisdictions, as it's referred to, the course of the proceedings in action, the judge offers their opinion that mediation may be of assistance to the parties. So the judge may look at a case and say to the parties, have you tried mediation? Would you like to try mediation? And advise the parties to attend upon an approved mediator and will adjourn the proceedings to enable that attendance. Now, the Resident Magistrates Court Amendment to Rules 1999 provides for agreements for mediation proceedings to be binding on the parties, and the terms of settlement are endorsed on the court's records. If a settlement is not achieved, then the case is heard and determined by the parish court judge. We also have access to the Criminal Justice Reform Amendment Act of 2001, which give judges the authority to issue mediation orders before commencement of trial. Now, the types of matters referred at the parish court level with respect to this are cases related to protection orders, recovery of possession, custody and maintenance, rent owing, unlawful wounding, assault under certain sections, assault occasioning actual bodily harm, any offense under the Trespass Act, any offense under the Towns and Communities Act, and any offenses under Section 4 of the Solid Waste Management Act. And we have also access to the Noise Abatement Act. Noise abatement, we had an issue in Kingston, well, we had an issue in Jamaica, really, where there's a lot of noise in terms of parties, and noise abatement was brought into position. And of course, this was allowed to be used, mediation was allowed as a tool to be active in there. And of course, the Malicious Injuries to Property Act. So as you can see, that there are a number of different criminal justice matters that can also go to mediation. And you can see where some of these acts here refer to things that may be personal to people, or even family members. So it does allow the use of mediation. Then we have Part 74 of the Civil Procedure Rules, 2002. Now, our Civil Procedure Rules have incorporated mediation into it. So it's actually part of the court process. It enables court automatic referrals of cases to mediation in the Civil Justice Supreme Act. But now, I want to pause for a minute. There's been a lot of talk about mandatory mediation And is it, should we have it? Jamaica does not have mandatory mediation. Let me be perfectly clear. It has automatic referral to mediation. There's a difference. The difference being is that when you file your claim form in the Supreme Court and the defense is filed, it is automatically through Part 74 referred to mediation. However, at this stage, there is an option to opt out of it. You could have a good reason that you may want to make an application to the court. You may have tried mediation already privately and it may not have worked. Or a number of different good reasons why mediation would not work. So it's not mandatory, it's automatically referred. Now, the reason Part 74 was created was to improve the pace of litigation, promote early and fair resolution of disputes, reduce the cost of litigation to the parties and the court system, improve access to justice, and also improve user satisfaction with dispute resolution and justice system. And that's very important. If you have users who are satisfied with what they're getting out of the justice system, it does help. Also to maintain the quality of litigation outcomes so people do not go back into court, they own the solutions and things like this. Now, it's very important we look at Part 74 and recognize that this has been in place from 2002. 21 years we've had it in our system. And there's been lessons learned. And we have evolved and grown. And we here in Jamaica often share our experiences around the region and literally around the globe in terms of our experiences utilizing this sort of system within our court system. It also, Part 74 also allows judges to order parties to attend mediation and for parties to consent to mediation. 74.3, in which a case management conference has not been fixed before September 18, 2006, the matter shall be automatically referred. A matter may be referred to mediation at any time prior to a pre-trial review by the consent of the parties. So up to pre-trial, you can still go back to mediation. And a matter may be referred to mediation at any time by order of a judge or master. Wide variety of matters include division of company assets, family-owned companies, personal injury, and matters like this. The processes or the services offered by the Dispute Resolution Foundation are mediation of cases at the parish court and Supreme Court level, non-court referred matters, mediation cases for communities, training institutions, civic and professional organizations. We also do sensitization for corporate bodies, small businesses and service clubs, and facilitate community meetings and dialogue. So anywhere there's a dispute, as we like to say here, from the bedroom to the boardroom, we get involved if we're asked. And we also do mediation training courses. Let's take a look at our rates, our success rates. You can see on the screen there, we've got our parish court mediation referrals from 2017 to 2022. And we can quite proudly say we've had a 79% agreement of rates going over the years. As you can see, we've had the spikes 2019, 2020, 2021, and 2022, which is approximately 1,677 mediation referrals. And the foundation has facilitated over 1,500 parish court mediations since 2017. Supreme Court mediations. The DRF has received over 4,000 mediation referrals from the Supreme Court to date. I probably believe it's a little bit lot more than that. The foundation has facilitated approximately 2,177 Supreme Court mediations since 2017. And 1,145 matters were scheduled for the year 2022. So you can see the system is in full swing. The number of mediations held are by no way reflective of how many were scheduled. Last-minute cancellations are frequent occurrences due to unforeseen circumstances, clashing schedules, parties unwilling to attend mediation. So there are some drawbacks, but generally speaking, the Supreme Court mediations are scheduled and they do go ahead. I want to take a look now on the effect of conflict management within society. Let's talk a bit about schools. In Jamaica, we have peer mediation. Pilot scheme have now and are being introduced to basic, primary, and high schools. Deans of disciplines are being sensitized to mediation and other conflict resolution techniques. So, as you can appreciate, children emulate or imitate what they see. And therefore, we start at the school level, introducing to them mediation and conflict resolution. So once we enter into, we have this deans of disciplines who are sensitized to mediation and other conflict resolution techniques that they can also apply. And we also apply it in schools. One successful school system is the Bermudian school system that actually successfully integrated peer mediation across the board and had a fantastic success rate. And it is also emulated throughout the region. School intervention program, the SSI program, school suspension intervention program. The DRF takes in children, of course, with the assistance of ministries, the Ministry of Education, various other ministries, who have been suspended for related issues. So you may have a child who's been suspended at school. That child may be referred to the SSI program, and the program assists with that student. Say the student has anger management or other issues, and it seeks to identify such areas that can be addressed. Sometimes this means parental involvement and/or professional involvement. It may involve, a parent coming in to recognize the child needs help, psychologically or otherwise. But the school intervention program, the ultimate aim is to reintegrate that student back into school. It has a high success rate, and usually the child returns to the program to assist with mentorship. Students continue to assist long after they leave school. So it's a win-win situation. In fact, this is an award-winning program that has been replicated in other regional jurisdictions. In fact, this whole topic here could in fact be an entire seminar on this too. Communities. So we've talked about the schools, where the children are, the communities. We have conflict resolution centers that are deployed with a number of conflict resolution techniques. And these are delivered primarily through the use of ADR mechanisms, such as mediation, restorative justice. Now in Jamaica, there are 14 parishes, and each one has at least one conflict resolution center. Some have more than one in volatile areas and have their own centers. In fact, I noticed when I scanned across the participants, I believe, if I'm not incorrect, one of our parish coordinators, Mr. Junior Campbell, is on board, and he operates the Clarendon DRF Conflict Resolution Center, which is very successful, by the way. Parties are encouraged, where possible, to use the centers or mediators or RJ practitioners before seeking redress in the courts. And of course, we work hand in hand with the Ministry of Justice as a team to actively decrease these sorts of issues as they occur within communities. Generally speaking, the mediators and RJ practitioners are on the ground and can be deployed very quickly. And the initiative in Jamaica is supported, as I said, by the Ministry of Justice, the Ministry of National Security, and the Dispute Resolution Foundation. So already, as you can see, mediation and RJ work as a partnership. They're not competing with each other. They work together, as most ADR mechanisms ought. In our legal system, so we have several ADR mechanisms that are deployed there. So we've got our school system, let's go over it again. Children going home to their communities, we've got the communities who are engaged, and we have our legal system that employs arbitration with an unsexual-based arbitration act, which we have in Jamaica. As such, arbitration awards are enforceable in a number of countries and jurisdictions worldwide. It also indicates the type of place it is to do business. So if you're on the business index, which you ought to be, you'll realize that, okay, they've got, what sort of justice do they have there? Do we have a quick redress? Do we have to wait in the courts? We've got arbitration. Mediation, as stated, we've got them in the parish court mediation as well, Supreme Court mediation, and private mediation. Now, it's important we recognize in Jamaica, we have a fairly new initiative whereby if you go to the parish court and you want a mediation and you cannot afford a mediation, the government will pay for the mediation. So in essence, if you want a mediation, you can get a mediation in the parish court. I think it's a fantastic initiative and it's in full swing here in Jamaica. And of course, we've got restorative justice. Restorative justice practitioners operate out of restorative justice centers and often provide an opportunity for access to justice and a deeper healing between anonymous parties. So what that basically means is that we have an incident or we have issues that take place. We're not only worried about the settlement, but also the healing of the community, because this sort of healing affects other people in the community and wider society. So RJ is very well placed to deal with that as well. And sometimes you have a situation where you have mediation, RJ going back and forth and resolving the issues in tandem. And then we've got the other leg of the stool, the fourth leg, if you will, trade and commerce. Now, trade and commerce offers the greatest opportunity to utilize and benefit from the ADR mechanism shown on this slide. Of course, you've got arbitration, which has been upgraded to reflect the unsexual model law now. Mediation, which has been operating in Jamaica for over 30 years and which parties are somewhat au fait with and familiar with. And recently, the Singapore Convention has been adopted with a view to being ratified. That's important. The Singapore Convention almost mirrors the arbitration type of model law, if you will, and allows parties to start seeking to mediate. Already, we're seeing globally, worldwide, how this is being affected. The United States, I believe, the United States, United Kingdom, India, and China have ratified the Singapore Convention. So already the four of the biggest economies in the world have made this move towards mediation, signaling mediation is coming of age and where its role is going to play. And of course, there are hybrid mechanisms where you have mediation, arbitration working in tandem to resolve matters and maintain that business relationship. And of course, businesses now are looking at ways and means of getting cost-effective, easy access and timely justice. Of course, you've got negotiation, which is just plain good faith discussions. This needs to be taken back on the table and really implemented in your dispute resolution clauses, whereby you agree to just sit down and have a good faith discussion to see if you can resolve it. We talked about conciliation before and its benefits. And of course, it's adjudication. Adjudication often used in contracts, building contracts, whereby it allows parties to have an adjudicator and abide by the adjudicator's decision while they continue to do their business. You may have a major building complex, an adjudicator. You know you're going to have issues, building issues, supply, time issues, what have you, but you can continue doing your business while the adjudicator adjudicates on the matter within their terms of reference. And of course, businesses are learning to become quite savvy in creating dispute resolution clauses that can lead to ease of business despite their disputes. So of course, you may start off with good faith negotiations. If that doesn't work, you agree to mediate. If that doesn't work, you agree to arbitrate and so forth and so forth. So the results, a cultural change in approach to conflict in Jamaica. Schools, children are the building blocks of any society. We know this. Communities, They're the fertile ground for cultural change to conflict resolution through ADR mechanisms. And courts, citizens who are sensitized to various mechanisms will begin to use these first. And trade and commerce, it bodes well if the jurisdiction is an easier place or environment to conduct business despite parties expecting issues. So we look at the entire society, the scope of society. We have children who are learning from the grassroots up, the communities that are providing that environment, the court systems where we seek our justice, and trade and commerce where we do our businesses. We start approaching conflict from a different perspective. What happens? What does this lead to? It leads to transformation. There we can see Nelson agreeing with us. Transformation. We have mediation training courses, basic mediator course is 7 days. So our mediators are certified and trained and gazetted. And that means that you cannot operate in the court system as a trained mediator without going through the courses. You have advanced mediator training. And of course, if you've taken the training and you decide not to use it, you want to refresh, we have refresher training courses. And of course, we have the trainer courses. But I'd say this, whether you want to be a mediator or not, whether you want to practice mediation in terms of the profession, I would still encourage you to take a mediator's course, whoever you are. Not just lawyers, anybody, take a mediator's course. These courses allow you to understand yourself and your approach, more importantly, the conflict resolution and your biases, internal biases you may have that you didn't realize you had. But it does help. And if you do that, of course, charity begins at home and you're able to reach out in your daily life and use it. It's really worth your while. Jamaica becoming a mediator, you apply on the website, you complete 56 hours basic mediation training, you're recommended for gazetted, you become a Supreme Court mediator. You conduct at least 5 mediations at the parish court level, complete advanced mediation training, and success with the interview panel. And of course, you're recommended to be placed on the roster of the Supreme Court mediation. So there's a process to becoming a mediator. And of course, this is reviewed by our Chief Justice and then gazetted. We do have basic mediation courses, and of course, these courses are delivered online over a 7-day period, and has theory, practical components, and what have you, and are available if parties wish to partake. We have advanced mediation training programs as well. Once again, the advent of COVID caused us to pivot. And of course, these are delivered online, and it's amazing what can be done online. Of course, we do practicums as well. I talked about the refresher mediators courses, and we do quite a few of those. And it's targeted at trained but inactive mediators, as I said, who want to refine their mediation skills. And it also allows us to hone and sharpen mediators' ability to conduct mediations. Of course, training of the trainers, those of us who want to become trainers, we have training courses. We use our 30-year experience to guide trainers to be able to deliver the product and deliver the message of mediation and ADR across to those who are willing to, who have come to the course to learn. And this is a particular skill. And of course, all of these are certified. You will receive a certificate of training. In Jamaica, we have 605 gazetted mediators, as you can see, spread across all the parishes. So they're not just in Kingston, the capital, or the second city, Montego Bay. They're right across, and as I said, the DRF has places throughout the island, in all the parishes, and are easily accessible. So in concluding, Jamaica, through the partnership of the government and through the Ministry of Justice, the judiciary, the private sector of Jamaica, and the Bar Association, formed this entity, the DRF, over 3 decades ago. The continuing education, implementation, and training in ADR mechanisms is providing positive developments and a cultural change to our society in Jamaica. That's very important. It's taken some time, but as you can see, it's a four-pronged attack, and it's not just any ADR mechanism, it's working together, a cultural change. This, I believe, and I truly believe, it is a game changer in societies such as ours, who need to revert to good old-fashioned discussing matters first and cascading all the way up to resolving disputes. Not always seeking your day in court, but let me add this. There is a place for litigation, and litigation will always have its place in my heart and in my mind, but not everything needs to be litigated. Jamaica will continue to be an example of how ADR can be successfully integrated into society as it ensures that it plays its role. The role I'm talking about is the role in the United Nations 2030 vision, the 16th goal. Look it up. That ADR has to be at the front of any sustainable development. The 2030 vision of the UN states in the 16th goal, and I agree that ADR has to be at the front of any sustainable development. And I think, fellow dispute disruptors, users, stakeholders, that with this and focus, we really can make a world of difference, not only in our societies and in our regions, but globally. The fight is on, but I'm sure with your assistance, we will continue to do our part. Thank you very much for hearing me this morning.
Thank you, Mr. Bassie. And it is an excellent presentation where we could understand the step-by-step how already a mediation mindset has been there in Jamaica. And it is, like you said, that it is playing its roles very effectively, right, starting right from the school level, the business community, and the society, everywhere. And I believe that in our country, in India also, the time is ripe enough to think in those terms. Of course, our nation is very big compared to your country. But said that, I think we must at least try towards reaching that goal, as you said, in 2030, 7 years to go. Let us hope for the best. And I would like to ask the participants if they want to, either they want to share their thoughts or ask any questions. So they can please raise their hand or write in the chat box. I can see one. No. There is no question as yet. Okay, I can see one, but they are going very fast up. How to make zero-sum game? It's very difficult. Santan, can you read it out or send it to me? How to make zero-sum game minded?
The question is how to make zero-sum game-minded legal professionals to be ADR friendly.
Mr. Bassie, if you can, please.
Okay, can you just repeat the question for me, please?
How to make zero-sum game-minded legal professionals to be ADR friendly.
Okay, well, if I'm understanding the question correctly, where do we begin? I must admit, I'm sure it's not a phenomenon that the legal profession or attorneys were at very first resistant. The way that it works best is when you try it. When you try it. Most people, having tried mediation with their clients, recognizes that, hey, I'm able to have a say. So I think the critical thing is trying it. Some attorneys will think that, oh, you're taking food out of my mouth, it's not going to court and that sort of thing. But on the contrary, if you prepare properly for mediation, you're able to resolve that mediation. It provides you with time to do other things, other important court matters. Also, your clients appreciate it because you've saved them time, energy, and money, and also resources. And they start appreciating the use of the justice system. So how do you start? You start by trying it. I think parties here, if you're an attorney, you should always say to your clients in preparing them at the initial interview, there may be an option to settle. How many of us, when we have that initial interview, and I can only speak for attorneys, say, there may be an option to settle. If you're not an attorney, maybe another profession, you discuss it with persons and say, hey, there may be options to settle this matter without actually going all the way to a trial or a court. So how do you do it? You try it. That's what you need to do.
Thank you. There's a question from Deborah Maloney. I can see it. Did the peer mediation program in schools require funding? And if so, how was it funded? Okay.
Initially, it was funded, the DRF asked the schools to assist. But as time went on, the value was cited. You found that the Ministry of Education got involved, and sometimes other ministries would have programs that would allow us to fund over a term, if you will. And eventually they started to fund and fund and fund until we found out that parties were recognizing the importance of such a program and would seek the funding prior to the term, and they would come on board and provide us with the meals and what have you and move along. And not only in one particular parish, but in other parishes too. So it's funded either by the schools and or with the help of the systems of government as well. We also had private sector. When I come to think of it, there were other private organizations that would come on board. I believe USAID, I don't want to talk out of term, but organizations like that would fund from time to time. Good to hear, good to see you, Deborah. Good to know that you're there.
Santan, can you see more questions?
How is commercial mediation in Jamaica? Is this mediation mandatory or optional one?
No mediation in Jamaica is mandatory. Let me just say that from the beginning. No mediation is mandatory. We have in the Supreme Court, we have referral to mediation. So you automatically, you put your claim form in the registry, the defense goes in, and then a form is issued and says, you parties are being referred to mediation. Now let's say it's a commercial mediation with two major companies that have in fact gone to mediation already. They may say, make an application to the court and say, Judge, we've gone to mediation already. There's in fact 5 issues, we've distilled it down to 2 issues, and we want to go forward. So the judge may say, okay, then let's dispense with mediation. That's what we call automatic referral to mediation. Mandatory mediation, as I understand it, is that the court is saying, oh, you must go to mediation. You can't force people to mediate. You can say to them, it's recommended you mediate. I don't believe you can tell people just get on with the mediate. That's not the way to go. And that's been our experience over the years, that we refer them to mediation. Of course, there's some resistance sometimes, but when they get in the room, because their attorneys may say, let's try it. Because remember, at any point in time, the mediator can tick the box that the parties met and they didn't resolve the mediation. So the option to not mediate is always there, right? So we have automatic referral to mediation. I hope that answers the question.
There's one question, Dr. Kishore Dere. Do you think advent of Singapore Convention will persuade international commercial disputants to choose mediation? I mean,
yes.
The country.
Yes. Before you even finish the question, yes. And why do I say that? The very process of mediation, a mediator, facilitates the discussion of the parties. So the parties get to come into an environment, without prejudice environment, where they can discuss real issues, and sometimes issues that are not even in the pleadings. it's cost effective, it's timely, and of course, it's access to justice. And what does that mean? That means in business, time is money. And businesses will look at the bottom, realize that this will affect their bottom line. Totally. You only have this nebulous figure on your strategic or your expense sheet where you're not sure how much is legal fees and that sort of thing. You may still not know what they are. But one thing's for sure, if you have a number of disputes per year, you can kind of figure if half of them are settled in mediation, that might affect the bottom line. So parties are looking at ways and means of using mediation, not only settling disputes, but within their organizations as well, creating that culture of resolving disputes. Because remember, societies have become very litigious. So if you've got a culture of resolving disputes, a person is not just going to run out through the company for no reason when you've got access to resolving those disputes and everything else. So the culture of mediation, I think it's here to stay. I believe it is, and I believe it'll evolve even more. I think we're just on the cusp now. Four of the biggest economies in the world have embraced it, and that says a lot.
Mr. Ajay Pratap Sharma, he most probably has two questions. May I please ask Mr. Sharma to, directly ask the questions? Mr. Ajay Pratap Sharma, are you there? Okay, I can see Mr. Ajay Bansal, you have raised your hand. Mr. Ajay Bansal.
Yes, thank you. Excellent presentation. My question is, what is the success rate of mediation in Jamaica, sir?
Okay. In our parish court, which has been under review in terms of allowing parties to have their mediations, we have a very high success rate. I would say 80% or more. In our Supreme Court mediations, we have been getting up to about 70%, maybe a little bit more than that, in terms of success. But remember, this is important. Mediation success is not in the 3 hours. I've often said to persons, the way you really measure mediation, the success is after the mediation. All right, let's go. Let's start some other way. Any court case has a finite value. Judge's time, appellant's time, litigant's time. There's a certain amount of money that goes into a case. And that increases as you move towards trial. Once you start mediation, if you stop it there, you've saved all that money. If it goes to case management and the party hears that their case is in 2027 or 2028, and they say, speak to the guy over there, ask if that offer's still on the table, I'll take it. Mediation was successful, we claim it, right? If you go all the way up to trial and they're still battling points and they recognize that trial is going to be very costly, we claim it again. So the savings in mediation has to be viewed in terms of not going to trial, all the way to trial. So success, to me, is if you're able to pass the issues, parties understand the issues and understand why they're going into that system of X number of years and going into their pocket to spend X amount of dollars. Once they recognize that, they start to view things differently. And guess what, too? If they go back to court, they ask for mediation. They come and ask for that first. So I find it to be very successful from that perspective.
Thank you, sir.
Mr. Anish Wadia, I think you have a question, please. You can directly ask the question, please. Mr. Anish Wadia, I can see your hand is raised. Mr. Anish Wadia. Okay, next is Aruna Kalavala. Ma'am, please ask your question.
You're muted, ma'am.
You are muted.
Good evening, everyone. My question is, what is the ratio of lady advocates in mediation?
That's a good question. But I want to say this, and I say it very carefully. We have a matriarchal society. So women are very involved in our society, you know, very, very involved. You know, our Jamaican women are not only athletes, cooks, singers, chefs, they're leaders, they're politicians, you know, so our female input, in fact, I'll go further than that. One of the chief proponents of ADR is a person called the Honorable Donna Parchment. Donna Parchment, along was the person who spearheaded it with the assistance of the stakeholders to form the DRF. She was our first political ombudsman and our first lady of ADR. So if I say 50-50, I might be wrong. It may be more than that, to be quite honest. But we have no issues there at all.
Thank you so much.
Thank you for the question.
Thank you, sir.
Ms. Manasi. Hello, Ms. Manasi. Yes, please.
I'm not hearing you though.
We can't hear you. No, we can't hear you, dear. Some problem. Mr. Yogesh Sharma and Mr. Anish Wadia, he said that he can't unmute himself. Rahul, if you can please help him.
He has the rights to unmute himself.
Mr. Anish Wadia?
Hi, can you hear me now?
Yes, yes.
Hi, thank you very much. My apologies.
Can you switch on your video, please, while you are asking the question?
I'm unfortunately in transit in a taxi.
Okay,
so,
that's okay.
I don't want that to be too disturbing. Okay. So you'll have to do without my good looks right now.
Okay, that's okay, fine.
My question, John, thank you very much for a very insightful presentation. However, and I'd like your comment on this proposition I'd like you to consider. I'm deeply concerned with the manner in which we seek to train and convey and talk about the term bias, because the term bias in itself is a very serious bias, because today, by simply talking about bias, we attach a rather negative connotation to the term, because we can have both a positive bias and a negative bias, and therefore simply referring to bias with a negative connotation could, you know, from a social-cultural, anthropological perspective, and also keeping in mind clinical psychology, because look at what happened in England during Brexit. The majority of people, when they were interviewed post-voting, said, look, the term exit was in the term Brexit itself, which inclined us towards that. Do you believe it's time, when we're talking about mediation, particularly providing training to participants in these various training programs, that we move and shift away from simply talking about bias with that negative connotation and focus more on a holistic approach by talking about bias in both positive bias, that it is good and it is potentially very good for a mediator to have positive bias, but it is not good to have negative bias, and make a very clear distinction between the two. Because there are also, we live in a world today where cultural dynamics play an important consideration in this thought process too.
I welcome that question. Thank you very much. I think it's a very important, valid observation. Of course, biases don't have to always be negative. They sometimes can be positive. And if we even look at, and I think you're quite right, you learn about your positive biases in a training program as well too. And of course, I have mediated on several different continents, several different regions, Jamaica, United States, Africa, England, different cultural areas. And cultural sensitization is very, very important. And therefore, a bias towards that can be a good thing, not necessarily a bad thing. And a sensitivity, if you will also assist in your experience as a mediator. So I think that's a very good observation. And maybe we ought to be pushing more in terms of saying there are positive biases out there and they can assist the situation. Thank you so much for that comment.
Thank you.
I can see a raised hand by Mr. Yogesh Sharma. Mr. Yogesh Sharma, you can unmute and ask the question, please.
Thank you, ma'am. Sir, very good presentation. So my basic question is, sir, what do you see the future of ADR, if possible, in international conflict? Sir, apart restorative justice of transitional justice which take place, do we have any attempt towards international conflicts and how we can settle these, for example, like today, Russia and Ukraine? What are the different perspectives of ADRs or mediation into that, sir?
Okay. Very good question once again. The future of ADR. Well, let's put it this way. I strongly believe that ADR is here to stay. There are several different mechanisms. I believe it hasn't reached its apex of evolving to where its full potential. But as parties, I heard it best today, I think Sanjita said it, that it's not new to a number of our societies. This way of dealing with matters, it's not new. It's not new to traditional societies. We are used to talking things out, whether it be tribal issues in Africa, where even now some of those practices are being codified, different types of ADR. I think that as parties begin to recognize that there are other ways of settling disputes and talking things, it will permeate throughout the globe. We once heard that, mediation and arbitration, you can't have Mediatorb. It's come full circle where now Mediatorb is being practiced. It's being practiced in Singapore. It's being practiced in Singapore in a way that quite admirable. We have the Singapore International Mediation Center on one floor, on the same floor as the arbitration center, and they will independently operate. But when a matter reaches where it needs mediation, it goes down the hall, and it may even come back up the hall. So you're not working in silos. ADR seems to be working in such a way that it is sorting out issues or resolving disputes, not only in the court systems, but in our communities. And if we sensitize our children, sensitize them, a number of things will take place, not just transformation there, but transformation in the courts. The courts can operate as they were meant to operate. There's nothing wrong with litigation. Sometimes you need a judge to sort things out. And that's what they do, and they do best. But you can't have judges wasting time doing things that a mediator can mediate and facilitate, or there's a family issue that restorative justice can take care of with mediation or conciliation, or even evaluation, judicial evaluation, which is another tool. There are a number of tools, and it's not alternative, it's the appropriate dispute resolution mechanism, not one size fits all. I hope that helps.
There is a question from Kautilya Kukunur. We said it is a good thought to integrate ADR into society. How can we make it possible in India, considering India, the lot of cultural differences? And what would be like the mechanism to fund this? Well, if you can, please.
This is clearly my opinion. My opinion is India knows Indians best. India understands its own culture best. And therefore, with all these sensitivities, as my friend was talking, and positive biases too, you're able to look at your own system and recognize what it is that you want to inculcate in your children. You can start at a very young age. And of course, communities. Why wait for court? You can have a community center where I believe in the past you had the Panjit, if I pronounced it correctly, the Panjit, where you had people sit down and try and resolve disputes within the community, assist. So India has the infrastructure. It's just for India to wake up and say, this is what we want. And then, once again, that's my opinion.
Mr. Courtney Gordon, he says that great presentation by John. The content, if considered against the particular context, that is culture, issues, and institutions, would not be difficult to create the desired transformation in any society. So the mindset can be developed. As you said, that starting from the peer mediation in schools, in families, in communities, in business arena. So, but the will, maybe the political will or the, it has to be there. The will from each and every strata of the society must come forward and go towards that, achieving that goal. Are there any questions? I can't see any raised hands. No.
There is one question from Raki Budiraja.
Yes, please, Santan, please.
Peer mediation is a good aspect among mediation. How can we start peer mediation in India and make it more effective? I think peer mediation is necessary aspect among the students.
The good thing is this, that in our industry of dispute resolution, we succeed by forming partnerships. We're not in competition with each other. So if I'm doing something good in the region, my region, reach out. Ask the experts, how are you doing this? We want to emulate it. And as I said, we have our school suspension program in Jamaica. Reach out to us. DRF, reach out. Tell us what it is you're planning to do. We can assist, we'll assist. Bermuda has an excellent peer mediation program. In fact, one of the former president's wife of Global President of the Chartered Institute, Jeffrey Elkinson, his wife, Fiona Elkinson, was the head of it. So reach out. If you see something happening somewhere, reach out. We do, we will, we shall. And we will help. We're in our region. We reach out to our sister islands, and they reach out to us. So that's what we'll do.
So, Santan, I think it is time that we should reach out in different, like peer mediation and whatever, and they are doing so well in Jamaica. They can help us. So maybe Nivaaran can start thinking in those terms. I don't know. Anybody? Manasi Kavaramma, she cannot unmute again. Rahul, please, if you can help. Manasi Kavaramma. I can't see anybody. So
maybe you should type it, Manzi. Maybe you should type the question. Type the question.
there are so many questions, but it is very difficult to pinpoint the question. It's going up and down. I don't know.
I think we are reaching 45 minutes. I think we can call it a day.
Yes, yes.
Can I ask a question?
Yes, yes. I can't see you.
I'm Bella Bhatt, advocate.
Okay.
Bella. Yeah.
Okay.
So I have a question, like I want to take it further from what Sangeeta ma'am said. How can we have effective mediation or ADR in place so that conflicts or war can be avoided for the betterment of the world? I mean, as a whole, like we have a conflict right now going on in Manipur.
Not only Manipur, in other states also.
Other states also, what is going on? How can we have something effective some effective mediation or ADR so that people or politicians, like you said, have to come forward and agree on mediation, or at least have some sort of negotiation or dialogue instead of just people fighting each other for no rhyme or reason. I mean, there is rhyme or reason, but then, I mean, how far can people keep warring like that and killing everybody? Each other?
I attended, that's a very good question for discussion. I don't have the answers for that, but I did attend a meeting a few years ago. A number of countries in Africa met, and they're contiguous with each other. And they were very concerned that if there's an issue in one country, it would ignite in the other and get out of control. And civil society met from all the countries to try and see what mechanisms can be put in place when conflicts arise. How best can we handle it as a group? Maybe that's something that can be considered in civil society. I don't know, at least as an initiative, to see where it goes.
Sareem Khan, I can see your hands are up. So please unmute and start your video if you want to. Yes.
Good evening, ma'am. Good evening, everyone. I'm a practicing advocate in Delhi High Court. It's wonderful having you all in front of me and have a great interaction with you. I'm just asking a ground reality question, as we are just trying to globalize the ADR, but the ground reality is that ADRs is becoming too much costlier. How can a layman, a single individual can afford this ADR? Because a mediator is charging too much hefty amount of money. Then how can economically weak people can afford this ADR to resolve their issues?
If just one second, if I may say so, in India, you can file a matter, I mean, file the application in the court and then get it referred to the mediation. It is free.
I'm just trying to ADR, arbitration process.
Arbitration, okay.
Okay.
Yes, sir.
Right.
Mr. Bassie.
Generally speaking, arbitration is not normally between single party litigants. It's normally between companies, businesses, who have, generally speaking, have agreed this in their contractual form. But in terms of the ADR question being affordable, it's a very real question. That, I think, was one of the things that kind of pushed our system to looking at it. Persons who could ill afford even getting to court on time with public transport, how could they afford ADR? So that is why when they got to court, in the lower courts, if they wanted ADR, wanted mediation, the government was willing to pay for it. Also, we have with the DRF a means test. So in other words, if you want a mediation, you'll get a mediation. That's the bottom line. But you may need to go through a means test. If you can't afford it, then certain questions will be asked, certain proof will be provided, and you'll get your mediation.
Definitely,
so
sir. Definitely.
It can't be one size fits all, because some people cannot afford dispute resolution, right? Or even a lawyer for that matter. You know, sometimes I wonder if I can afford a lawyer. But I mean I'm joking. But seriously talking, it's a very serious question, and we have to keep ADR affordable. Very important, and I think it will be, because it is that sort of mechanism that creates a win-win environment for all concerned, all society, and resonates throughout the regions and globally. Yes, any other questions?
Just one question I can see. It's Carol Higgins from Jamaica. Are there any specific initiatives for targeting churches and other religious groups to advance? Then I can't. No, I can't see anything.
I think what she's asking in terms of certain civil society groups, in particular churches.
Okay.
It's always been encouraged for church groups to have maybe mediation within their churches. I know there's a couple in Jamaica that have done it in the past. Carol Boulevard Baptist for one. Our own Carol Madden, who sat on the board for a number of years, spearheaded some directives like that. So, and we also do train management teams, whether they're church or otherwise, sensitize them to the benefits of it, and having trained mediators within the ranks to resolve issues. So yes, reach out to the DRF, see what has been done in the past, and if you've got an initiative, speak, and let's see what we can get done.
So there are a couple of questions, but I think the time is up. Or Santan, please tell me.
You can close it. Now we have crossed 6 minutes.
Okay. So let me say, sir, it is wonderful to have you today in this great session, but often we find it difficult to get the parties on board to agree, even to mediate, especially in private mediation or pre-litigation mediation. So before approaching the adjudication process, parties must be advised to go through the mediation process once. And this does not take away the parties' voluntariness to settle. Like you said, in Jamaica, it is automatically auto-reference mode. It is not mandatory, but it is on auto-reference. Here, advocates play a much greater role so as to help create the required comfort level for parties. Now this session is coming to an end. In the third session tomorrow of this wonderful virtual summer school, we will learn about mediation, its definition and process, the differences between mediation, conciliation, arbitration, and litigation, the lacuna and disadvantages of adversarial dispute resolution, where you will have Ms. Diana Sonava Dapa, Deputy Attorney General and Deputy Minister for Justice, Ghana, as the guest speaker. Here I must thank Nivaaran, SIMC, and CLA to give us this opportunity. Mr. Rahul Kumar, advocate, who helped us all to reap the benefits of these wonderful sessions seamlessly without technical glitches. Finally, thanks to our organizers, members, registrants, and participants. We will wait for you all tomorrow at 5 p.m. sharp. Thank you.